Thank you, Your Honor. Just as a housekeeping matter to start, there will be the issue of restitution. That is, the documentation is being gathered, and we ask the court would defer that for 30 days so we can present it in an orderly fashion and make sure it's comprehensive for everyone.
Any objection to leaving restitution open 60 days? All right.
Thank you, Your Honor. I think it's necessary and appropriate to share for everyone here, including the court, the background that brings us in front of Your Honor today for these proceedings. As the record reflects, and as everybody in this courtroom knows, the defendant has pleaded guilty to all 5 counts charged in the indictment. Under oath before Your Honor, he has admitted that the charges against him are true. He has reassured the court that he has not been coerced or threatened to make those admissions. And Your Honor did an extraordinary job in taking the pleas back on July 2nd. We appreciate the court's discipline and insight. The defendant has also waived appeal on the multitude of rulings from this court and Your Honor's predecessor in Latah County on dozens, literally dozens of motions seeking to dismiss the case, seeking to control or limit evidence, seeking to offer evidence that would not be appropriate. And we appreciate the court's consistent rulings based on the law, based on the facts. As Your Honor will recall, on June 18th, it's just really not that long ago, we appeared before this court for arguments on what became the defendant's final motions to this court. Motion where they wanted to offer evidence suggesting that other people were responsible for the defendant's actions, and the motion seeking essentially an indefinite continuance of the trial. It was readily apparent to all of us in the courtroom from Your Honor's comments that those motions were not going to be granted. So we returned to Moscow and continued with what we had been working on for months in preparation for trial. We had no qualms about going to trial if trial was what was necessary and appropriate. The following week after we were in court, we were approached by the defense with an inquiry about a possible plea. And I can tell the court this is the first suggestion ever that there was any consideration, because indeed, the defense had maintained from the beginning that Mr. Kohberger, the defendant, was factually innocent. It's clear that the reality of the evidence and the case that had been investigated and prepared and that we were ready to present in court became a reality. Our reaction, among other things, was to reach out to all of the families. And in fact, later that week, on Thursday and Friday of that last week of June, we met with representatives by teams, virtual meetings, with representatives of all the families. And we talked about the status of the case and the upcoming trial and things that related to the trial. And we also let them know that there had been an inquiry about whether there might be an offer for a plea. And we asked the family members for their thoughts and feelings. And they were candid. And they have been candid since, and we respect that. And we understand, recognize, and acknowledge that there was a difference of opinion among representatives of the different families. We understand that. One of the challenges of this case, one of the unique things about this case is we have multiple victims, each unique unto themselves, their families and friends unique unto themselves, and all of them entitled to their opinions, all of them entitled to their thoughts. Over the following weekend, our prosecution team, very skilled attorneys who were personally as well as professionally deeply invested in this case, met. And we talked, and the decision was reached. Well, to start with, were there to be any sort of plea offer or discussion, there's only one possibility. And that would be for the defendant to plead guilty straight up to all charges. There would be no bargaining about counts. There would be no bargaining about reduced sentences. And so we made the proposal to the defense that if the defendant was willing to plead guilty up front to all 5 counts as charged and waive appeal of the court's myriad decisions during the past 2.5+ years on all these motions that would have consumed years, if not decades, of time in the future. By the end of the weekend, we were notified the defendant was prepared to plead guilty as charged and factually acknowledge his responsibility in court for these horrible crimes. Obviously, those discussions and negotiations were confidential. And as Your Honor noted, I believe, that was necessarily so, because if the defendant had decided not to plead guilty, it would have been devastating to our jury pool for there to be public information that there had been consideration by either party to a plea resolution. And protecting the prospective integrity of a trial after so many years was paramount. So, the end of the weekend came. We notified the victims' families of what had occurred. I recognize and acknowledge personally, and I respect the fact that of these fine, suffering people here, not everybody agreed with the decision we make. I accept that. It's my responsibility in the end. I recognize that that's the duty of the office that I hold. So now, it is time for the judicial system to impose final judgment and close the door on this chapter of these tragedies. As the court is aware, by the agreement of the parties, it is the state's prayer. Perhaps have the Elmo police turned on. Thank you. That on count 1, the felony burglary, that the court sentenced the defendant to the maximum period of 10 years fixed in the custody of the Idaho Department of Correction. Then on count 2, that the court sentenced the defendant to fixed life for the murder of Maddie Mogan. On count 3, that the court sentenced the defendant to fixed life for the murder of Kaylee Gonzalez. On count 4, that the court sentenced the defendant to fixed life for the murder of Xana Kernodle. On count 5, that the court sentenced the defendant to fixed life for the murder of Ethan Chapin. And the state further prays that these sentences be ordered to run consecutively, back to back, not at the same time, to recognize and respect the unique individuality of each of these beautiful young people whose lives were taken brutally and for no reason. And hopefully now, as we have heard earlier this morning, it is time to afford the families and the friends and the community and the state of Idaho and the nation and the world to move forward. We can't undo, and we can never undo, the horror of what occurred on the early morning hours of November 13th, 2022 at 1122 King Street in Moscow, Idaho. For a long time, the presiding district judge in Latah County was John Stegner, who eventually became a member and a justice of the Idaho Supreme Court. And Justice Stegner often observed that even God cannot change the past. But everyone in this room has the ability to take themselves forward. And we want the judicial system to afford them the opportunity today to do that. From today forward, our memories should be focused on these innocent victims whose lives were taken, on their families, on their friends, on the community. The court has heard discussion, talk today, reminiscences today about a special family that our victims shared, not just their natural, legal, and biological families, not just their university family within their sororities, for example. But this family. This is the picture taken on November 12th, 2022, of the special family of 1122 King Road. And you can see all 6 of these dynamic, vibrant, loving, special, innocent faces taken together just across the street from their residence, and barely 12 hours before 4 of them would be brutally murdered in their sleep. They've been described consistently as being bright, caring, vivacious, with futures we can only imagine now. But they were, and they remain, a special family that I think we should all recognize and appreciate. So it's time to move forward. There have been a number of statements directed specifically at the defendant today. I have one last thought. After Your Honor imposes judgment and sentences the defendant to spend the rest of his life in prison, in other words, sentence the defendant to die in prison, he's going to stand up in the belly chains and the leg irons that he's wearing today, and he's going to be escorted into the custody of the Idaho Department of Correction. And the door will close behind him forever. That is the closure that we seek, that all of these people, these loving friends and family deserve, so that we can move forward. Thank you, Your Honor.
Thank you. All right, does the defense have evidence to present today?